when I set this many, many months ago, I told everyone I was setting it very far out so that everyone would have the opportunity to prepare. I also put specifically in my order setting this trial that I was not going to entertain any request for continuance at the last minute. The parties have had every opportunity to try and pursue resolution short of trial. The fact that this is apparently just coming up on the eve of trial is not extraordinary circumstance. I don't see anything else in your motion that would qualify as an extraordinary circumstance. So I'm going to deny the motion unless you can tell me that there's something that's not in your motion that I'm missing.
Well, since the last court date, Your Honor, our discovery received by defense has grown from 8,000 to about 32,000 pages. So we're still trying to review the discovery in order to be prepared to actually effectively represent him in a trial that would take place, I guess about a week from now. Additionally, Friday afternoon, after the motion was filed, there was more discovery received, recorded interviews and whatnot, and some more records. And my understanding is the medical records of the victim, which are extremely voluminous and haven't been completely disclosed, have been actually digitized so that my office can go and review those and copy those from the police department. So we have been diligent in trying to get through the discovery. It's just exceptionally voluminous in this case, Your Honor.
Well, if it hasn't been timely disclosed, Mr. Molina, I can just enter an order precluding it from evidence. Why doesn't that solve the problem?
No, I'm not objecting to that.
All right, Mr. Cohen?
Your Honor, we've been working diligently. There's been over 32,000 pages of discovery in this case. Mr. Molina, defense has...
Mr. Cohen, just because there's 32,000 pages doesn't tell me anything. I mean, it could be 32,000 pages of nothing. This case doesn't strike me as one that is that factually complex. So I don't understand, I guess, A, when did you disclose all this discovery?
We've made disclosures consistently over time. Defense has made additional requests for disclosure based upon information that we've disclosed.
That's correct.
There have been ongoing requests for disclosure.
Mr. Cohen, that doesn't tell me anything. It doesn't tell me why the state's waiting to disclose this information, how it's conceivably relevant to any information in this case. This case needs to go to trial. So tell me why the state is only now apparently disclosing 24,000 pages of information.
Your Honor, we have been disclosing everything all along. There have been additional requests for disclosure.
If that's the case, then there's no reason for continuance, right? Mr. Cohen?
The defense has made this request, Your Honor.
I know.
The state has no objection to this
request. Is the state
request.
ready to proceed?
Not next week, Your Honor. The state would at least need another additional 2 weeks to prepare. We anticipated that this matter would be continued. There are, again, numerous witnesses that have to be involved. If this court is insistent on making this case go to trial in the next few weeks, then the state would at least ask for a continuance within the last days.
And we would need time to do the interviews at the very least. And there's still, Your Honor, there's quite a bit of discovery to get through. It's extremely voluminous. In order to represent him, I know you said it could be nothing, but we don't know until I look at it. So I do have.
When did you receive it, Mr. Molina?
So it was after the last court date.
Which was like 4 or 5 months ago. So when did you receive it?
What the date of the discovery?
Oh, as I've said, my computer hasn't booted up yet.
Let me check. All I know is
Continuous disclosure as we've received it, Your Honor.
Mr. Sutherland, let me ask you, you understand that if I continue this case, which I'm frankly not inclined to do, but if I do continue the case at your attorney's request to give him the opportunity to look at this additional discovery, whatever it is, that any time associated with the continuance would be waived or excluded under your speedy trial rights. So you understand that and you're willing to waive time, correct?
waive time. Your trial time is what it said. So you have the right to have a trial before March 26th. So, waive time. You can waive time if you want more time there. So let the judge know.
Are you willing to waive time, Mr. Sutherland?
Yeah, I need more time, please.
All right. So I still feel like I don't have much information, Mr. Molina, so tell me exactly what you need to review, how many pages. Because when I set this trial, and I thought I was clear the last time,
So I
it's
still
going to be a firm trial date. I'm not going to continue this trial again. So tell me how much time you need. I'm going to give you that much time, and I will not continue this case again for any reason, period.
60 days will be pushing it, I know that much, so.
Well, no, I don't think 60 days is pushing it. You've had months and months and months.
We still have to do witness interviews.
Well, then you better start, Mr. Molina.
Okay.
I'm going to grant the request. I'm going to make it for 60 days. Time is waived under Rule 8. So, Nick, what's our new date 60 days from now?
For the FTMC, Thursday, April 23rd. For the trial, Thursday, April 30th.
When our new last day?
May 30th, 2020.
Think further.
No, Your Honor, thank you.